Senator Huffman, you ready for 1124?
Sure.
We're going to go ahead and call it out. Chair lays out Senate Bill 1124 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Members, when the legislature passed the Michael Morton Act in 2013 to revise criminal discovery, it used the term "the state" in a manner that blurs the role of the prosecutor and the investigator or agencies in providing discovery to the defense. As a result of this ambiguity, the Texas Court of Criminal Appeals in June 2024 held in State v. Heath that a trial court may suppress relevant and incriminating evidence of a defendant's guilt for failing to disclose it upon request, even when a prosecutor had no knowledge that the evidence existed at the time of the initial request. This ruling applies even when the prosecutor acted in good faith and the defendant suffered no prejudice from the non-disclosure. Unfortunately, defense lawyers are now taking advantage of this technicality by not specifically requesting evidence that they know a law enforcement agency has failed to turn over to the prosecutor. Then at trial, the defense can invoke Heath to have it excluded. This gamesmanship undermines the integrity of the trial process and the core principles of justice. Senate Bill 1124 seeks to rectify the unintended consequences of the Heath decision, which permits the suppression of inculpatory evidence without requiring a showing of bad faith by the state or harm to the defense. Members, this bill does not apply to exculpatory, impeaching, or mitigating evidence benefiting a defendant, nor does it prevent a court from suppressing evidence in cases of bad faith by the state or incurable prejudice to the defense. The bill clarifies the definition of the state, quote unquote, for discovery purposes, distinguishing the responsibility of prosecutors from those of law enforcement agencies. The bill also establishes new procedures for requesting discovery, empowers courts to limit overly broad discovery requests, and codifies pre-Heath common law standards governing the suppression of evidence. I'd like to thank the elected prosecutors for working on this legislation with my office, helping make certain that the Michael Morton Act is being preserved and implemented as intended. This change will ensure that our criminal justice system is weighted equally for both victims and the accused. That's it.
Members, any questions? Senator Hinojosa?
Thank you, Mr. Chairman. Just a couple of questions, Senator Huffman.
Yes.
From the Heath case that you discussed and talked about, in that case, there was an issue about who represented the state, the police or the prosecution.
Correct.
The DA. And it clarified that both represent the state. But in those type of situations where police officer withholds evidence that may be exculpatory,
Right.
how do we encourage the police officer to release that information if they just withhold it, and then there's no way that the criminal defense attorney knows about it?
Well, I will say that this bill does not touch at all the current law that would apply to that situation where exculpatory evidence that was deliberately withheld. Clearly, the law is very clear on that, and this bill does not address that nor change current law or what's being practiced in the courts or the responsibilities of law enforcement and the state as it regards that.
And I know that's your intent, but I guess I don't see it in the body of the bill. So it might be a good thing to just add that language that it does not include exculpatory.
I think if you look at it, and of course there are prosecutors here that I'll let them specifically address that because we have discussed that, and it's not the intent of the bill, nor will it change common practice. If we think it will, we'll fix it, but I would like the prosecutors that are here as invited testimony.
Well, and we should work on that. I really, I know what the intent is, but I just want to make it clearer. The other issue has to do with it seems like we're changing some of the wording and usage that we use in the present legislation on the Morton Act to sort of narrow the discovery which can be provided to a defense attorney. Is that your intention?
I don't think that's the intent. Again, this is going towards inculpatory evidence that perhaps had been in the knowledge of the law enforcement, but the prosecutors didn't necessarily have it. And again, sometimes tactics are used to try to, suppress that evidence by the defense at the last minute. But again, the prosecutors can address those specific issues and give you examples of that.
And one more question, and that is, right now, under present law, we created a portal so that all the evidence could be placed in the portal and available to both the prosecution and defense attorney. But now you have in your bill certain, I don't want to call it restrictions, but I guess guardrails, if you will, on some of the evidence that may not be relevant. How will we go about dealing with that issue? I guess
I'm not sure I understand your question, yeah.
My question, I guess, is what impact would this bill have on the portal, the lab portal? It seems to me that there's right now we passed legislation to make sure that the portal was not caught in the middle of any disputes between the prosecution and defense attorney. And the way the bill is written, it would seem to me that if the judge is going to limit evidence that's or requests that are overly broad, how would that impact the use of the portal?
I don't think it impacts it, but again, we'll ask the process. I don't believe it's intent to impact it or what the rules are. I think it's just clarifying when the evidence can be placed and if it's not, whether it affects what's admissible. But again, I'd rather the prosecutors.
No, and then we have Brett Mills also here from DPS that works on that issue.
Okay.
But I also have a suggestion on that might help clarify that. If
We'll always look at what you might offer, and then we'll see what we think.
Thank you, Madam Chair.
Okay, sure.
Any other questions? Other questions? Chair now opens for invited testimony. Chair calls Brett Ligon, Sean Dick, and Brian Middleton.
We have a bipartisan panel here, Mr. Chairman. So that was the intent here.
Perfect. We'll begin to my right. If you'll state your name, we represent, and you may proceed.
Good morning, sir. My name is Brett Ligon. I'm the District Attorney in Montgomery County, Texas. I've been the elected District Attorney for the last 17 years. I believe that perhaps I may be up here because I was one of the few elected District Attorneys that was in the room when Michael Morton was promulgated. And Michael Morton is a beautiful man. His story is so important and impactful. And maybe it's because Easter's on me, but I am reminded that Jesus wept at the tomb of Lazarus. And every prosecutor in that room wept, and it's our worst nightmare to think that an innocent man would spend time in prison. And 3914, which was promulgated as part of it, is a beautiful effort, but it's like a child, it's clumsy. We were told at the time that 3914 would be fixed, it would be refined, it would reflect the search for truth. When Michael Morton visited this august body, Senator, you and I have practiced together, this body, and he said his search was for the truth because he was denied the truth. Because Williamson County, Sean Dick is now the elected DA there. Williamson County had this archaic policy called a closed file policy. The only DA's office in the state that was practicing it. It kept Michael Morton from knowing the truth. It kept evidence from him that the state knew about, but they wouldn't test it. But y'all didn't stop there. Y'all then promulgated another rule, Chapter 64, that would specifically allow testing. It's been fixed over and over and over and over. What Senator Huffman's bill does is deal with one particular issue. It's the suppression of evidence. Think about evidence, right? Our job, we have the best duty. We're the only people in this whole building that have a sworn duty to seek justice. And seeking justice means finding the truth. And you can't have the truth if you have partisan judges who have their own agendas deny the jury the opportunity to see truth. The Heath case had nothing to do with truth. Separate the man from the mechanics of discovery. Michael Morton is an inspiration. It inspires all of us. You'll hear Jarvis Parsons, the elected DA in Brazos County, talk about how we all embrace it. We bought the book. We shook the man's hand. We preach it because we want it. But these mechanics are flawed. Criminal law is supposed to be about the search for the truth. A suppression by itself is oppressive. It's aligned with terms like fruit of the poisonous tree, prejudice, and harm to a defendant. Heath erased all that. Senator Huffman seeks to restore that. It deals with the suppression issues that say, wait a minute, Judge, before you toss evidence, you've got to show some malignancy on the part of the prosecutors. You have to show some prejudice to the state. And by the way, adopt a remedy that the court in Heath said that the legislature should be doing. Texas Court of Criminal Appeals Justice Newell asks you to interpret his words. It's in Heath, written there, and he says the legislature can come and do this. And that's what we're doing. So the Texas Court of Criminal Appeals punts it to y'all and says, hey, do something about this, define it. Senator Huffman has offered up a bill. My cohorts are going to do an incredible job. And please point out, purple, blue, red.
Yeah.
Red. This is a very bipartisan effort to show and to demonstrate how discovery gets to the truth. Thank you, Senator Huffman, for this bill.
Trying.
Thank you. Good to see you.
Purple.
Good to see you, Mr. Chair. So next time I won't make the mistake of sitting next to Mr. Ligon. I'll sit next to Mr. Middleton on the other side. My name is Sean Dick. I am the District Attorney of Williamson County. I realize the irony in that the Michael Morton legislation came out of our county. But I believe very strongly in that legislation. I think it was a very good change to the law. I happen to be a defense lawyer at the time that case was going through the courts. And I watched it very closely. I was actually an attorney associated with that case. So I know the ins and outs, and I understand what the intentions were. Now back as the District Attorney of Williamson County, I'm starting my 8th year. And I've just seen that there are a lot of issues that the Michael Morton case didn't initially address. The biggest that I'm going to say is just the change in the amount and volume of evidence that comes to our offices. So we review about 3,500 felonies a year. And at any given time, we have 1.15 million pieces of digital evidence for 26 lawyers to look at. 1.15 million pieces of evidence. Now, that might be a piece of paper. It might be an entire video, audio, cell phone dump. But there's 1.15 million pieces for us to look at, and we want to give over 1.15 million pieces to the defense lawyers. The problem is, with the volume of evidence that we're dealing with, sometimes they're just going to be things that we don't catch right away. But somewhere down the line, we'll catch them. And so there's a burden that's put on our prosecutors where they feel like they're now just digital evidence managers. They're not attorneys. They're not prosecutors. They're busy handling digital evidence. We need some guardrails in place so that the judges can make some rulings and have some thoughts about how far this goes. To give you an example, I know sometimes people think the Heath decision is just a hypothetical, but we have defense lawyers that are poised to use it at the drop of a hat. I mean, 30 days after a case is filed, and keep in mind, we give discovery within 24 or 48 hours sometimes. But we have lawyers that are ready to file a Heath motion 60 days into the case being filed. And in fact, we had an indecency with a child by sexual contact, indecency by contact case involving 4 children under the age of 14. And while the case was pending, it gets set for trial. The prosecutor realizes the police had the defendant's cell phone in their custody. They worked with the law enforcement agency. They got a search warrant. The judge signed the search warrant. And guess what we found on his cell phone? All sorts of child porn. And not only did the child porn corroborate the testimony of these children, but the child porn actually could lead to additional charges and in fact included pictures of the children themselves. We had a visiting judge come here, a Heath motion, and said, well, it just took too long. It sat in the police custody for too long. I'm going to go ahead and grant a continuance, but I'm going to suppress that evidence forever and ever. So we have evidence of child porn in a child abuse case that will forever be not usable simply because a visiting judge decided, based on the Heath decision, that he could do it. And so we're asking that there has to be some findings, there has to be some rules put in place so that the truth does come out and we as prosecutors can follow our duty to see that justice is done. So thank you, Senator Huffman, for filing this. And thank you, Mr. Chair. So appreciate it.
Thank you.
Thank you. I am the blue one, as I indicated. And I'm here testifying in favor of Senate Bill 1124. I think I'm the only one of the three that's also a certified police officer. I support law enforcement. And one of the things that I'm keenly aware of is that I don't have direct supervision of police officers. We had an experience in Fort Bend County where we were trying a murder case, and from the witness stand, we found out that there was additional body cam. Now, we have good judges in Fort Bend County. We did not have that evidence suppressed, but we had no knowledge of these other body cams. We do our best to make sure that we obtain all the evidence and turn it over, but not having direct supervision of police officers can lead to unintentional evidence not being turned over. And Heath, I think, went way too far, made it a strict liability. If you don't turn it over timely, then it's a violation of the statute. And then said, it's up to the court's discretion whether or not to suppress it. Well, I think 1124 fixes that problem and requires that there be some finding of bad faith. And what I encourage you to consider is that what we have to remember, and we heard the witness testifying earlier, that we speak for the victims. And so when we have evidence excluded, there may be a denial of justice just because one judge decided that without a finding of bad faith and no intention of excluding evidence, that evidence was excluded. I think that price is too high. I think our citizens deserve more. I think the victims deserve more. And I think we ought to be able to try our cases based upon all the evidence and not have excluded where there has not been a finding of bad faith. So I encourage you to pass this legislation and protect victims and protect justice in Texas.
Well, thank you all for being here. Any questions, members? Senator Huffman, you like?
No, I don't. I'm sorry, my light's just.
Senator Hinojosa?
With the blue.
Yes, sir.
And I agree. I mean, it's a big issue and a big problem when police officers don't turn over the evidence, and quite frankly, the DA is not aware of it. In the Heath case, that I don't necessarily agree with the decision the way it was made, but you talk about good faith or bad faith. How do we end up dealing with that issue when there's evidence that's being withheld, and all of a sudden it comes forward after during the trial? Like when you were asking questions of the witness, all of a sudden you find out there's another video available, camera. How do you deal with that issue and the problems there? Typically,
in my experience, the way it's been handled, there's a hearing that's conducted to determine, what caused the evidence not to be turned over. And prosecutors are put on the witness stand, police officers, everyone. So there's a fact-finding to determine what caused the failure. And so then that's how we make a finding. And what this bill does is require that there be a finding.
And if the finding shows that there was not done in good faith, it was something just inadvertently done, then it would be that the evidence come in against the defendant.
Yeah, or remedied by continuance, whatever it is that's necessary to allow the defendant to have a fair trial. But we already have in place remedies for these different type of situations, but he took some of those away. And to address your concerns about Brady, there are numerous laws, there's constitutional law that requires us to turn over exculpatory evidence. And failure to do it can cause you to lose your license. So your concern about exculpatory evidence, I think, is covered even under state bar rules. So I don't think this Senate Bill 1124 creates any problems in terms or jeopardizes exculpatory evidence not being turned over, because I can tell you that's a heavy burden for all of us that we take very seriously, because the three of us can lose our license if that occurs.
Yeah, the DA for Williamson County at that time lost his license. One more question. That's I guess so. If you find that the evidence was held in bad faith, not necessarily by DA, but by the police officer, could the evidence still be suppressed?
I think, yeah, the judge under this proposed statute, Senate Bill 1124, I think the judge would then have the discretion to exclude it because the police officer is part of the state. So if they found out that the police officer intentionally did it, then that would be bad faith and could be taken into consideration. Another thing I wanted to add is that I spent 16 years as a defense lawyer, so I've seen both sides, and I just like Mr. Ligon pointed out, I mean, we all appreciate and respect the Michael Morton Act and the need for it, and we all want to, seek justice. And so I think this puts us back where we need to be, to where we're able to try cases and not have some judge with an agenda exclude evidence. So I think this goes a long way in protecting justice. So, thank you.
And just one more question, and that is, if I may, you spoke about being overwhelmed with digital evidence, and but who will make the decision of whether or not certain evidence is relevant to the defense?
So, for example, in Montgomery County, we've gone to a paperless discovery system. So one of the portals that you were referencing, the defense bar has a portal. So we're under a continuing obligation under the Michael Morton Act, specifically 3914. So even after the case is over, we're still required, when we become aware of evidence, for example, lab reports, happens all the time. We'll get a lab report after the defendant has already pled guilty with the assumption that the defendant knew what he had, correct? And so we'll have to disclose those. Sometimes the amount may change. Sometimes the drug itself may change. But the discovery requirements, oftentimes from a judge, are very articulated. One of the issues in Heath was the guy says, "Can you give me the discovery?" So in almost all criminal courts, the courts have a very specific discovery rule, and it sets out all the basics. Most defense attorneys have a supplement to that. And I think this might be the only panel in which I practiced 10 years as a criminal defense attorney. Sean Dick practiced over a decade as a criminal defense attorney, and Brian practiced 16 years. So you're talking about people who have done both that understand that the search for truth is better for everyone. So what goes into the system? 3914 tells us a bare bones minimum of what goes into the system, whether it's witness statements, video, I'm trying to think other things. For example, grand jury testimony can't go into the system absent an order from the court. And so 3914 is a very robust rule as tells us right off the bat what we have to put into it. But I wanted to address your specific question. You asked about exculpatory evidence. Heath didn't even reduce that conversation as to whether or not the 911 call was exculpatory or inculpatory. Didn't even mention it. Just said, hey, suppressed. 3914H specifically says, notwithstanding any other provision, so regardless of what Senator Huffman's bill seeks to clarify in regards to suppression issues, H is still there, notwithstanding Senator Huffman. Any other provision of this article, the state shall disclose to the defendant any exculpatory evidence, impeachment, or mitigating document, right? And so we're already there. As Brian pointed out, we're subject to the state bar now. In 2013, the concern was raised between us and the defense bar, was this going to be used as a bar grievance issue? We were promised it wasn't, and now that it is. Even though the vast majority of non-disclosures, what are called inadvertent non-disclosure. In the particular case of Mr. Morton, the elected DA at the time lost his race. The DA that was handling the case not only lost his license, but went to jail. And so it's become something different in the sense that it is become weaponized. I don't believe that Michael Morton, who every time I ever spoke to the man, talked about the search for truth. He has no idea that he has been reduced to nothing more than a voodoo doll. They pulled him like a sword, and he has no idea that in court 1,000 times a day his name is blasphemed. They say, I will pull a Michael Morton. I'll file a Michael Morton sanction against you. It's Michael Morton this, Michael Morton that. And I always think to myself, he's a real man. He's a real man.
And I
But those
understand.
protections are already there, Senator.
Many times when we pass legislation here in the legislature, actually been in place for years, or you have different issues come up and bubble up, and then we try to come back and sort of address those issues. So I'm pretty much aware of some of the abuses that take place. When I file for discovery, I ask for everything, including the kitchen sink, but I name it under the discovery rules, criminal statute. That is very important. Otherwise, you're out there left out without proper documentation. I'll pass the witness here.
Thank you. But thank you all for being here. Appreciate it.
Thank you.
That was excellent. Thank you.
So members, we need to recess and reconvene after the session. Members, we have to go to the floor. Senate Committee on Criminal Justice is now reconvened. So invited testimony is closed. We will now chair open public testimony. Chair calls the following witnesses. This is on Senate Bill 1124. Amy Waddle, Joe Patton, David Gonzalez, and Brady Mills. Amy Waddle, Joe Patton, David Gonzalez, and Brady Mills. Thank you all for being here. We'll begin on my right, and you state your name and who you represent, your position on the bill. You have 2 minutes.
Thank you. My name is Joe Patton. I am an attorney with the Capital Murder Division of the Dallas County Public Defender's Office, and I am opposed to SB 1124. Would you like me to continue, or are we going?
You have 2 minutes. You can just.
Okay. Well, before we begin, the invited guests had spoken a bit about Michael Morton and their interactions with him. There was an implication that Mr. Morton would support SB 1124 and that he felt somehow victimized by his name being used in the capacity as represented by the invited.
Could you move the microphone just so we can hear? We want to hear you.
Yes.
Thank you.
It was indicated that Michael Morton supported this and that there was a personal conversation that Michael Morton feels somehow abused or used up by defense counsel with his name and the discovery. Given that, I actually called Michael during the break, and he gave me permission to tell the committee that he does not support this, that he is familiar with it, and he does not recall making those statements. So I want to begin with that. Michael does not support this. Now, if the intent of SB 1124 is to reduce ambiguity and avoid, as the invited witnesses stated, unfavorable judges, SB 1124 fails. The question presented is not whether evidence exists. The question presented is who is responsible when there are evidentiary failures. And the current legislation shifts the burden and the responsibility off of prosecutors and onto judges and potentially law enforcement. Under the current law, prosecutors have, as they stated, a duty to seek justice, which means they have a duty to know their case and they have a duty to know their evidence. When they have evidence under the current law, they are to disclose it. That is the end of the analysis. There is no ambiguity. If it exists, you disclose it.
Thank you, sir. Perhaps there'll be some questions in the follow-up. We'll listen to all the witnesses, and then if there are questions, we'll come back. Thank you for your testimony.
Thank you.
You may proceed. Your name, who you represent.
Thank you. My name is Amy Waddle, and I work for the Montgomery County District Attorney's Office. I'm in the appellate division there, and I also participated on the committee that helped to draft a response to the Heath decision from last summer. Just in response to the previous comments, there is actually ambiguity in the current version of 3914 as to who in the state is responsible for conducting criminal discovery, at least under the interpretation of the state and Heath. So it is necessary to clear up the roles and responsibilities between the different members of the state, and this bill does that. This bill also does not curb the discovery rights given under the Michael Morton Act. It does curb the power of trial judges to penalize the community for inadvertent and ultimately harmless discovery violations. I think there was some mention earlier of the just increased volume of disclosures of evidence to be given over, which is going to lend itself to more violations. And so what do trial courts do when that happens? Well, there used to be a body of case law that set rules for trial courts to follow when a discovery violation occurred. Under those rules, the appropriate remedy for most violations, like late discovery or late disclosure of evidence, was a continuance for the defense to review and prepare to meet that newly disclosed evidence. Under those rules, exclusion of evidence was considered an extreme remedy that was reserved only for situations involving a willful, bad faith withholding by the state, or when the defendant was actually harmed by the late disclosure. But Heath upturned that body of case law and kind of pretended like it didn't exist and declared for the first time that trial courts have the inherent authority to elect this extreme remedy of exclusion of evidence, regardless of whether a lesser remedy would suffice, regardless of whether the trial prosecutor knew about the evidence and intentionally withheld it, and regardless of whether the defense was actually harmed by the withholding. And that's a key here because the idea of harm is familiar.
Finish your sentence. You can finish your
The idea of harm is familiar in criminal law. Trial errors happen, and the law recognizes that each trial error is not automatically reversible. But the Heath decision essentially made discovery violations essentially a basis or explicitly a basis for exclusion. And that is just not consistent with anything else in our law.
Thank you. Yes, please.
Hi, I'm David Gonzalez with the Texas Criminal Defense Lawyers testifying in opposition to the bill. One of the things that made the Michael Morton Act such great public policy is it recognized that discovery doesn't belong to the lawyers. That it really took this idea of particularized discovery that the civil lawyers fight about into portals, which you talk about. So then we're uploading all of the data because there is so much on these devices that everybody is recording. And there's no longer these individualized reviews. I'm reviewing it. My paralegals are reviewing it. Like last week when the prosecutor was unaware that on the body cams, the officers say to one another, I hope somebody watches this. This kid should not have been arrested. They can play this in court. The brass above me, they disagree, but my decision, his decision was not to arrest. And until you watch 7 hours of those videos, it's very hard under the changes. There's 8 changes to the Michael Morton Act here. 5 are unrelated to Heath, and those are the 5 that we're focusing on, which make discovery more narrow than civil discovery by requiring specificity, by saying I have to prove why it's necessary to my defense. To navigate privacy interests that we don't have in civil cases, that the court can't order more discovery. But, as to Section Q, I agree. It is a fantastic guardrail to say normally we have spoliation instead of exclusion. But if it was just that, I think our organization would stand down. It's the narrowing that moved 10 years ago to where everything had to be specified to this moving of all the portals that we would say that we should be consistent like we're doing with crime lab discovery. Thank you very much.
Thank you. Thank you for your testimony.
Good afternoon, Mr. Chairman, members. My name is Brady Mills. I'm the Chief of the Crime Laboratory Division of the Texas Department of Public Safety, and I'm on the bill. I'm here as a resource to address any questions. But in context to the Crime Lab portal, we reviewed the bill, and there's a couple points that may interact with the portal, but our assessment is that it doesn't adversely impact the portal. The portal will provide crime laboratory records in real time once they are administratively reviewed. The point that there has to be a written notice of discovery by the defense to the prosecutor, that still could work with the portal. Today, the prosecutors have to tell us who is the attorney on record, and so that written request from the defense attorney could be that notification to the prosecutor, so then we can give them access to the portal. The second piece about limiting discovery, the records that are automatically put into the portal, we would view, and we're working both with stakeholders from the prosecutors, from the defense, and then also from our laboratory and our local partner laboratories, is that the records that would be in the Crime Lab portal would not be in the burdensome or unduly broad category. And so that's how we have evaluated the bill, and be happy to answer any questions.
Thank you. Questions, members? Senator Huffman? Yep, for anybody on the panel?
Just on the portal, if I may.
Senator Mendoza?
So on the portal, this bill itself would not have any kind of impact or cause any issues as it relates to the evidence that's put in the portal by the prosecutor. It's accessible to the defense. And
Yes, if we could all, and we will all agree that it's not unduly or unburdensome type records that are in the portal, those will all be freely accessible by defense and prosecution post admin review of the cases that are worked in the laboratories.
so what happens if the court rules that it's burdensome and the evidence already in the portal? How do you deal with that?
So we would have to work with the courts and educate of why those records are automatically in the portal, but then we would have to comply with the order from the court.
Okay, so you don't have any issue the way it's written in terms of as it relates to the portal?
The only maybe potentially clarification is that we could exclude crime laboratory records from this bill, but if as we work through this with our stakeholders and we make agreements that the records in the portal are not overly burdensome or unduly broad, then we feel that we would be okay with those records.
Okay. Thank you, Mr. Chairman.
Thank you all for taking the time to drive all this way to come testify and give us your sage advice. Thank you.
Thank you.
Thank you.
Chair now calls Jarvis Parsons, Staley Heatley, Sam Bassett, and Emily Follansby. Emily Follansby. Did I pronounce that right? All right. I used to use phonics. We'll begin on my right. Welcome to you all, and please state your name, who you represent, your position on the bill, and you have 2 minutes.
Yes. Thank you, Senators. My name is Jarvis Parsons. I'm the Brazos County District Attorney. I am for the bill, and I'll start my 2 minutes. Thank you so much. I fully agree with my colleagues, Mr. Ligon, Mr. Middleton from Fort Bend County, and Mr. Dick from Williamson County, that this bill provides clarity and balance. One of the things that I believe is sorely missing right now in the state of the world post-Heath. We're here to provide that balance and separate unintentional conduct from intentional conduct and give us a scalpel instead of a sledgehammer, where many times evidence is suppressed even without anyone even knowing. I know in my area of the world, in Brazos County, we've had situations where we didn't even know about evidence on a person who was doing what we would call upskirting and going around to hundreds, almost thousands of women in our particular area. And we didn't know there was evidence there at the police station that confirmed many, many more images. And that evidence is then suppressed without any sort of intentionality on the prosecutor's part or on law enforcement's part. And so I think that clearing that up is super important. It allows and kind of gives clarity for a standard for judges to see that if they are going to suppress evidence, it's going to be because of fault on behalf of law enforcement or on behalf of the state of Texas, the prosecutors that are there. And in instances where it is not there, then a continuance, which was the remedy before post-Heath, is going to be something that is balanced, it's reasonable for both sides, so that defendants get justice, victims get justice, and the state of Texas all get justice. And the whole point of the criminal justice system is to search for truth. And so in order to have that, we have to have the evidence that is there. Absent intentional misconduct, I think that this bill, Senate Bill 1124, strikes the exact right balance that we need. Thank you very much.
Thank you. Thank you for being here.
Good afternoon, Mr. Chairman, members of the committee. My name is Staley Heatley, and I am the Wilbarger County Attorney, and I'm here to testify in favor of the bill. I've only been county attorney for a few months now. Before that, for 18 years, I was the district attorney in the 46th Judicial District. In fact, back in 2013, I was here at the legislature testifying in favor of the Michael Morton Act. And I think what we've seen over the last decades is anytime you have a piece of legislation that creates kind of a sea change in the way you're doing something, is that you're going to see that there are some things that need to be fixed after you've been living with it for about a decade, and that's what we have here. SB 1124 will help protect against discovery gamesmanship that has become all too common in our criminal cases. It provides guidance and guardrails for courts in handling discovery disputes. I think we just heard some testimony about some evidence that was provided, some body cam footage that had some exculpatory evidence at the end of it. That kind of evidence will not be affected at all by SB 1124. That kind of evidence will continue to be provided. Section H of 3914, which requires the disclosure of exculpatory, impeaching, and mitigating evidence, is unchanged. I had a case just last year. There was a domestic violence case where a man had a long history of abusing women, and on the day of our trial, the victim showed up and she testified, and her testimony went sideways, which isn't really uncommon. But what I found out that evening when I got home and we were able to pull jail phone calls is that in the days leading up to the trial, he was coercing and threatening her. So when I got to court, I sent that information directly to the defense attorney, and I get to court, that evidence had been in the possession of the sheriff's department. And here I am facing a Heath motion on something I didn't know existed, that the defendant knew existed, and now that case is on appeal, and I'm battling that issue there. So I support this legislation.
Thank you. Thank you for being here. It's a long way to travel.
Good afternoon. I'm Sam Bassett. I practice law about 2 blocks from here, so it's not too hard for me to get here. I'm a former president of the TCLA, and I sat at council table when Michael Morton was found guilty. I saw his legs lock up. I saw him almost pass out. And at the time, I kind of thought he might be guilty. And I was on his team. But there was a lot that we did not know. And so the Michael Morton Act comes along 25 to 30 years later after he serves 25 years in prison, and we begin to do an inventory of what can we do to incentivize the full disclosure of evidence. And we worked hard and a long time on the Michael Morton Act. And I understand the Heath decision has caused a lot of consternation. As I read Heath, it was a case that had had 3 prior jury settings. It was the 4th jury trial setting. A timely discovery request had been made many months before, and the judge decided, for whatever reason, that he was going to impose a sanction of excluding the 911 call that the prosecutor had learned 6 days before. Now, nobody said the prosecutor was acting in bad faith or knew about it before 6 days before, but I think that the judge felt the overall system, the state, as the judge saw it, was more than just the prosecutor in the courtroom. And I think that's the essence of the Michael Morton Act, is that we need to incentivize all law enforcement working on a case, police officers, arson investigators, give them the highest incentive possible to comply with discovery and Michael Morton Act. The Brady rule existed when Michael Morton was tried. We filed discovery motions which were ruled on. So we're not talking about basic discovery, we're talking about incentivizing the system to make sure that everything is turned over. Our concern at TCLA is this gives too much discretion to DAs to determine what is relevant information to be turned over. As we do it now, it's a lot simpler of a standard. Material evidence is to be turned over. Thank you for your time.
Thank you. So we're showing you're against the bill, sir?
Yes.
Thank you.
Hi, I'm Emily Fallensby. I'm the legal director of Texas Defender Service, and I am testifying against the bill. Senate Bill 1124 would roll back Michael Morton Act, and it would do so in 3 critical ways. First, the bill narrows the definition of what the state is to just the prosecuting attorney and original investigating law enforcement agency. This change creates an inadvertent incentive for other state actors with relevant information to potentially delay or entirely withhold it from the prosecution. If the attorney representing the state does not seek that information, the defense is left in the dark, an outcome we know contributes to the incarceration of innocent people and undermines public safety. Second, Senate Bill 1124 requires the prosecution to hand over only evidence, quote, relevant to a fact of consequence. However, this standard is problematic because it assumes the prosecution can accurately assess what is relevant to the defense without knowing the defense's theory of the case. Defendants have a constitutional right to present a defense, and the defense, not the prosecution, is in the best position to determine what evidence may support or undermine its case. Limiting discovery to what the prosecution deems relevant risks withholding material that could be critical to innocent defendants. Third, The bill requires the defense to make a specific written request for information. But how can a defense attorney request something they don't know exists, let alone narrowly tailor such a request as required by the amendment to Section A2? This provision creates a catch-22, one that denies defendants fair access to evidence and reduces transparency and accountability in the discovery process. All three of the proposed changes in Senate Bill 1124 strike at the heart of Michael Morton Act, undermining its spirit, weakening its protections, and destroying the balance it was meant to restore. The Michael Morton Act brought long overdue accountability to the discovery process in Texas, accountability that the bill would effectively erase.
Thank you. Thank you for your testimony. Any questions, members? Thank you all very much, and thank you for taking the time to give us your advice.
Thank you, Mr. Chairman.
Counsel.
Senator Huffman.
Chair now calls Caitlin Baker, Jenny Andrews, and Chase Baumgartner. Caitlin Baker, Jenny Andrews, and Chase Baumgartner. So we begin on my right. You state your name, who you represent, your position on the bill, and you have 2 minutes.
My name is Chase Baumgartner. I'm a staff attorney for the Innocence Project of Texas, testifying against the bill. As this committee knows, the Michael Morton Act is legislation born out of a wrongful conviction where a man spent 25 years in prison for a crime he did not commit. And as such, it hits close to home for our organization. And Senator Huffman, you stated that your intent was not to narrow the discovery obligations under the Michael Morton Act, but we share Senator Hinojos' concerns that it does for three key provisions. One, you just heard, that the changing of evidence that must be disclosed from material to relevant to a fact of consequence does narrow what must be produced in discovery. And for that same reason is prosecutors will now be making subjective determinations of what is both relevant and what is a fact of consequence. And unless evidence meets both of those standards, they can withhold it legally from the defense. And we know what the inevitable answer is when you withhold this evidence. It's that wrongful convictions will happen. The second is that discovery will only happen if the evidence is not unduly burdensome to produce. But this legislation deals with evidence that is either material, if unchanged, or relevant to a fact of consequence, if changed. So this is important evidence. So how is it ever going to be unduly burdensome to produce this important evidence for a defendant to have access to? And this is exactly why the Michael Morton Act exists, because when you limit discovery on this type of evidence, wrongful convictions happen. And the third reason is we have a competing interest of a core tenet of our criminal justice system, not to convict innocent people, being balanced against privacy interests of witness and victims. But the law already provides ways to protect these rights and these interests. That information, that sensitive information, can be redacted prior to ever being disclosed to defense or being used at trial. And so limiting discovery in lieu of, say, redaction is not a suitable way to do this. Thank you.
Thank you. Thank you for your testimony. Whenever you're ready.
Good afternoon. My name is Caitlin Baker, and I'm here not as an attorney, but as a layperson with a vested interest.
Yes, ma'am.
We all know the story of Michael Morton and his wife, Christine. 17 months after Christine Morton was murdered, my mother, Deborah Baker, was murdered by the same man. The reason that was allowed to happen was because there was a prosecutor in Williamson County who intentionally withheld information and discovery, and Michael Morton was wrongly convicted. The person who murdered my mother should and could have been arrested in 1986. That evidence was already in the custody of the district attorney's office and of the police, but it was not turned over to the defense as it should have been, and the wrong man was sent to prison and allowed this man, this murderer, to walk free for decades. Deborah was my mother. My brother and I were very young and we needed her. And that her death was preventable makes it so much worse. And we had to wait 28 years, 8 months, and 11 days to bring her killer to justice because someone else decided what was relevant to the defense. Someone else, a prosecutor, made a mistake and decided that it was not relevant. And so for that reason, I have to urge you to vote against this bill as written. Thank you.
Thank you, and we're sorry for the loss of your mom, and thank you for having the courage to be here today. Yes.
Good afternoon, Senators. My name is Jenny Andrews, and I'm testifying today on behalf of the Texas Catholic Conference of Bishops, where I am a policy analyst. We are opposed to SB 1124, which we believe does roll back key provisions of the Michael Morton Act. This act was passed unanimously through both chambers in 2013 as a result of a grave miscarriage of justice in the case of Michael Morton, who was wrongfully convicted and imprisoned for 25 years. The Texas bishops support criminal justice reform that provides for compassionate treatment of prisoners, responds to the needs of the victims of crime, and encourages rehabilitation and forgiveness of those reentering society. The strength of our criminal justice system depends on its accuracy, its ability to convict the guilty and to clear the innocent. But we know that wrongful convictions happen. Identifying and understanding the causes of wrongful convictions is critical to maintaining the integrity of our justice system, and every effort must be made to ensure wrongful convictions do not occur. Since 1989, in the United States, 3,659 innocent people have been exonerated after they have spent years in captivity. Thousands more are awaiting exoneration but lack proper representation to achieve justice. It's estimated that 2 to 5% of people in prisons are actually innocent. Of the almost 500 that have been exonerated since 1989 in Texas, half of the exonerations were cases where the prosecutors had exonerating evidence in their possession at the time of the trial. The gravity of such a miscarriage of justice cannot be overstated. Condemning the innocent makes a mockery of justice, robbing men and women of their dignity, relationships, time, opportunity, and personal freedom. Wrongful convictions also endanger the public because locking up an innocent person means the real culprit walks free. The TCCB's concerns are related to the limitation to a defendant's request for discovery in the bill as filed.
Thank you. Thank you for being here. Senators, any questions of these? Thank you all for being here. Thank you for your testimony. So there are no more witnesses, public witnesses registered. Is there anyone present here that wishes to testify on, for, or against Senate Bill 1124? Hearing none, public testimony is closed, and we will hold the bill pending.